about to list it today, but it is not listed. I have a screenshot of the website. The matter pertains to blacklisting. My lord, I am debarred from participating in future tenders. Tenders were floated. My lord, the next date, last date of submission of tender is 28. So I am looking for 27.
When did you file it?
My lord, it was filed on 30th November. My lord, notices were issued to the respondents. For interim relief, my lord, needs to be done.
Are the respondents served?
It is not showing in the website. They are not.
Check up and tell me.
I have checked it. They are not serving.
Without serving, how we can grant?
Not I'll because I have also given a copy to the advance copy to the council who normally appears for it. I'll ask him, my lord.
Put it in a box.
Lordship, I am requesting for the 439 bail. The date was shown on the
Put it in
7th
the
Feb, Lordship, and I want to prepone the date of next week, Lord, because the applicant is a student, Lordship.
Please put it in the box.
But in this Honorable Court passed the order 25/2022 and still the impugned notification issued by the state government Marat, then labor all the cases transferred from the labor court Bhopal to Hosangabad. This is the IR granted by the Sankar, but apart from that, 16/2003 respondent appear and appearance is marked on behalf of the petitioner Marat, and they have taken the adjournment, but IR is not continued. Therefore, Marat, the work of the labor court is stopped, Marat, then they have not performing the work. Marat, it may be, then I have also filed the recall, the order date is 16/2023, Marat. No, Marat, may can't be listed 27.
Put it in a box.
Okay.
I have read the affidavit filed by the state. So that affidavit. Lordship has raised the questions whether Advocate General appointed under Section 165 can be appointed as public prosecutor under Section 24(1) of CRPC for High Court of Madhya Pradesh or separate independent public prosecutor is to be appointed by the state. My answer is Advocate General cannot be appointed as public prosecutor for independence, removal from office without assigning any reason with change of government, and public duty of the public prosecutor discontinued. Further, MP state has notified state litigation policy, where there is a separation of public prosecutor and advocate general. Further, the MP government has amended the CRPC. Now I'll go in details. And this question partially I answered by rejoinder affidavit on page 276 of paper book, where, as per Supreme Court, AG neither represents a public interest nor is representative of the state government. This is decided by Supreme Court, and this is under 276 of the paper. To discuss subject, we have to examine function of two courts, duty of two courts under Constitution of India, Code of Criminal Procedure with the latest amendment by State of Madhya Pradesh and government notification, condition of service for discharging duty of two courts, oath of constitutional office of Advocate General, powers, privilege and immunities of the Advocate General and public prosecutor, process for their appointment, removal and tenure of appointment. This question also I raised on page 61 of the paper. Conflict of interest of two courts and case law. Further, MP government home department has made one Madhya Pradesh Abyojan Manual and Regulation made in 2008 by Directorate of Prosecution Home Department. Manual is pending for approval with the minister. Now, under RTI Act, when I asked the Office of Public Prosecutor about the public duty, the reply was that Office of Public Prosecutor is not covered, is not a public office. The function of the public prosecutors are statutory public authority who on behalf of public society, not on behalf of government and in the public interest, ensure the application of the law where the breach of the law carries a criminal sanction, taking into account both the rights of the individual and the necessary effectiveness of the criminal justice system. On this point, there is a research, Lordship Bishop, for the independence of prosecution.
We will take it after lunch, because it will take some time to argue. We'll
In the
take it-
meantime,
We'll take it at 2:15.
2:15, more time. In the meantime, here, This research on the subject can be taken. And I've served a copy on that.
215.
हमने नहीं स्टेप हमने थोड़ा बनाई बोर्ड में बन
Yes.
The vacating stay application was filed.
Yes.
The only matter is the date of birth, Maluk.
Ah.
The reference was made by the central government, Maluk. And the tribunal is given a clear finding, Maluk. And it's the order of the tribunal, Maluk, page number 15, Maluk.
So that is on merits, but
Yes.
why the stay should be vacated?
And because the money was not paid by the appellant. Due amount.
On merits, no, final hearing. But why the stay should be vacated?
On the stay, Maluk, I have not received the money, Maluk.
You have to wait till adjudication.
The cap, all the record kept in the appellant, Maluk.
What ground you have raised to vacate the stay?
Because the Maluk, the date of correction of the date of birth, Maluk, I have not do any at the time of appointment, Maluk.
No, that is on merits. No?
Yes.
The merits will hear you. What is your ground for vacating the stay?
Only for money, Maluk. I have not received the money.
Where have you stated so? There is no ground on this. The only ground is no question to stay the proceeding.
That all the question was raised by the appellant, Maluk, in the writ appeal, Maluk.
Ah.
That all question was raised in the writ petition also.
Correct. You have
But
to
the
raise same
London
question.
single judge had dismissed the petition on the case of the Bajnath, relying the Bajnath case.
Yes.
Thus the similar case is also the appellant respondent.
That we are reconsidering whether it is right or wrong.
Yes.
But there is not even a single ground for vacating. Vacating stay is on a different ground than final
Yes.
hearing. What is the ground to vacate? There's nothing here.
I have withdrawn this IE application to be filed fresh. Revised.
This application is filed by the respondent seeking to vacate the order. The order of stay granted on such a the only reason assigned is that is as stated in paragraph 5 to the effect that there is no question has arisen to stay the proceedings of the tribunal, except that no other reasons are assigned. However, we have considered the improved order once again. Terms of the said order petition was dismissed. Said order is given effect to the respondent herein would be reinstated with full back pay. In case that happens, then the question of reversing it at the stage of final hearing would not be possible. However, if the respondent would succeed, he would always be entitled to all the benefits that may be granted him. Hence, we find no good ground to vacate the I is dismissed.
Milord, pursuant to what transpired on the last day, Milord, we have prepared a synopsis of the judgments dealing with the effect of a stay order. Milord, Lordship would recollect this is the matter where blacklisting order was stayed initially, Milord, at the behest of the petitioner. He chose to withdraw the petition without getting an order on merits. So the question would be, Milord, whether the order of blacklisting would survive or it would get revived, because he has chosen not to obtain an order on merits and to get it quashed. Milord, from what happened last time, Milord, we have prepared a synopsis, Milord, of the judgments, Milord, which we could get on the field, Milord.
Is a ground for vacating.
Milord, the ground for vacating is, Milord, that admittedly, Milord, the facts are that within 2 weeks of the order of blacklisting, he obtained a stay, Milord. That stay order, Milord, I'll just show that to your Lordship, Milord. The order of stay, Milord, is at page 170, Milord. Just have a look at, Milord, page 170. This was about 2 weeks after the blacklisting order, Milord. It was 2017 November, Milord. The blacklisting was for 2 years. See, he obtains a stay on 7th December, Milord. Thereafter, Milord, when the petition comes up for hearing, the petitioner, Milord, at page 173 makes a statement before the court that according to him, the petition has become infructuous. And recording that statement of the petitioner, Milord, at page 173, the writ petition was dismissed as infructuous. Now, this happened, Milord, just a couple of weeks before his technical bid was considered. So the authority saw that the order of blacklisting has not been set aside or reversed by the Honorable High Court. He did challenge it, but chose to withdraw it. Milord, the petition was withdrawn on 14/9/22, and Milord, the technical bid was considered on 27/9/22, Milord, about 14 days thereafter. So he was disqualified on the ground that the order of blacklisting has not been reversed, it has come alive, it has revived. So that was the ground, Milord, on which the technical bid of the petitioner was rejected, Milord. So probably, Milord, the petitioner gave an impression before my lords, Milord, that the order of blacklisting is over. That is, the period is over, 2 years is over. But that was under the period when the order was deferred. The operation of that order was stayed by this Honorable Court. That did not run technically. And to that effect, Milord, we have enough judgments of the Supreme Court saying that, Milord, that there is a difference between a stay of the order and its eventual reversal. Milord, if your Lordship could just permit me to hand over that synopsis, Milord, we have quoted the paragraphs of the Supreme Court judgments, Milord, on the point. Although, Milord, on the last day also my respectful submission was that the effect of the stay was that the implementation was deferred. The order remained, it existed. And he chose to withdraw the petition. So that order freezing the operation of the blacklisting order comes alive the moment the petition is withdrawn without seeking an order on merits and getting it quashed. Milord, that's the only ground, Milord. Only ground on which Milord, it's a tender of transportation of food grains. Milord,
You have created the problem, you find a solution.
Milord, the food grains goes to the PDS shops, Milord. Once the tender is...
Does not mean your illegalities can be...
Sir, that is for my lords to hear the matter, Milord.
That's
But
what
then
we said,
hearing,
so we'll
Milord,
hear it.
Milord, on the point of Milord, Lordship granted indulgence on stay, Milord, only on the ground that the period of blacklisting is over because 2 years is over. Now, the crucial fact in between was that the order was stayed.
We are aware of that.
Yes.
The same thing you are saying.
Yes. I would leave it.
So that's why we have given passed a lengthy order to grant the stay.
Yes, your Lordship did consider the fact that. But then the legal position, my Lord, supports us. My Lord, this is what my respectful submission is. That the understanding and the legal opinion of the authority was that the order of blacklisting stands revived the moment petition is withdrawn.
Answered by us.
Yes, it has to be answered, my Lord. And as I submitted, my Lord, on 24 September 22, when we considered the technical bid, the petition was already withdrawn and he had intimated to us that the petition is withdrawn and now there is no order of blacklisting, which the authorities said no. The order of blacklisting stands revived. Lord, the public interest would weigh in our favor. Lord. It's a food grain transportation to the PDS shops, Lord. Otherwise,
Find a solution to overcome the blunder.
Lord, we can't bypass that, Lord. Once the Lord, from one place, storage place to PDS shops, Lord, if there is a tender, and
Still, we are not going to legalize just because.
I am not on that. Lord. I am only requesting, Lord, that Lord
That is what you are saying. That's exactly what you are saying. Yes, we have done illegality, it's all right, but public have to suffer.
I am requesting Lordships to just consider whether it's an illegality.
Floated the tender in the midst of the matter pending and a stay being granted. This is the only problem.
Milord, the blacklisting was not by us. Kindly appreciate that. It's, Milord, again, it's not a fact that, yes. So, Milord, blacklisting was by some other authority. So, it's not that we were aware that there is a blacklisting and then a tender was floated.
Nothing stops you from floating a new tender even now.
Come in contempt, Milord, that the same work is being put to tender, Milord. We would be in a different trouble then, Milord.
Seek leave and go. Can't it?
Then we'll move an IR.
If at all you are so genuinely concerned about the public, find your own solutions. We can't give you legal advice like this.
Milord, in fact, the effect of the prayer for vacating stay is, Milord, just to proceed with the tenders, Milord.
Not this tender. This tender is out of the question.
We'll move an IR, Milord. We'll move an IR.
May I just make
Well, for you can.
We'll do
Lord,
that.
I am the lowest bidder in this. I had already pointed that out, Lord.
We can't imagine what will happen later on. Whenever they file it, we will deal with it.
I am the lowest bidder, Lord. I've already, Lord, quoted my bid, Lord, in the.
You become a lowest bidder once again. Who's stopping you?
But if they open this bid, Lord, I am ready to do that work, Lord. I was there. I'm ready to do that work still. So if they are concerned about the public interest, Lord, I am the lowest bidder. I'm ready to
We
do
are
that.
not. We have already told council we are not getting into merits.
But I am paying for respondent number 3. Tender has been allotted in my favor.
Yes.
I have deposited the bank guarantee as well as my security note. That is in a R3.
You have
in
not
my
filed.
reply.
You have not filed IA for vacating.
So one, but I have had an reply has already been
Reply will hear you at final hearing.
one.
Lordship may only defer the hearing, Lord. We'll take appropriate steps.
For after
2 weeks.
at request of respondents, case is adjourned.
Fine.
Yes.
Lordship, same order was passed by Honorable High Court on 26/4/2005.
What is the default?
Kindly see annexure B for him. Chair for me.
Okay, subjection and jurisdiction is over to. Yes. Which are 615?
615. Wait, please allow. Follows the brief facts are. Follows in 2010, an advertisement was floated, pursuant to which, my lords, 150 people were appointed against 82 vacant posts. Now, my lords, these people came before this honorable court for confirmation of their appointment. Now, your lordship, this honorable court declined to do so and rather ordered an inquiry into the matter. So, Your Lordship, pursuant to the directives of this Honorable Court, and Your Lordship, even a FIR was registered in the matter, and the petitioner is a whistleblower in the said illegal appointment case. Thereafter, Your Lordship, after the judgment of this Honorable Court, directing the respondents to complete the exercise within 2 months, Your Lordship, an inquiry committee was constituted and the committee gave its finding. Now that finding was given to Ministry of HRD. Thereafter, my lords, Ministry of HRD said, we are again remitting this matter back to the university. Your Lordship, a public interest litigation was filed by me, taking into consideration the fact that the order of this Honorable Court was dated 8/3/2018, giving 2 months time to conduct the inquiry into the illegal appointments. Thereafter, my lords, even till 2021, the same did not happen. Matter was remitted back to the university. Your Lordship were pleased to issue notice in the said matter. Thereafter, my lords, I have filed an interlocutory application for interim direction. My lords, what is happening is during the pendency of this case, the people who were unsuccessful before this Honorable Court and who faced an adverse order into their own appointment, the inquiry order, my lords, the executive committee has passed a resolution wherein, my lords, it is resolved that professors appointed against rolling advertisement may be confirmed to the extent of vacancies advertised. That is 82, subject to the outcome of court cases pending. Your Lordship, we are aggrieved by this resolution passed by the EC, wherein they are proceeding to confirm those people who were unsuccessful before this Honorable Court, who faced an order by this Honorable Court of Inquiry. So that is the reason I have filed this application for interim direction. The judgment of your lordships at Annexure P to my lords, page number 24, it summarizes the entire case.
What was this P2 writ petition for?
My lords, this writ petition was filed by the illegal appointees seeking confirmation of their illegal appointment. They were 150 people appointed against 82 posts. So their lordship declined their relief. At the same time, even ordered inquiry. They were not confirmed. They were appointment, they were not confirmed. They filed the petition seeking confirmation. My lords, even their own very appointment was questioned. This Honorable Court went one step further and even questioned their own appointment and ordered the inquiry within a period of 2 months.
What happened to the writ petition ultimately?
My lords, the writ petition was dismissed with a direction that in 2 months the university has to undertake the inquiry into these illegal people.
The petition is dismissed.
Yes, sir.
Can directions be issued?
My lords, I will have to examine this aspect.
What is the scope of the writ court in dealing with that matter? It is for regularization. How the court can overstep itself and pass this order? And assuming it's a valid order, when the petition is dismissed, everything goes. Directions have not been issued.
My lords,
The directions are, it's a void. Even otherwise, if the inquiry report or whatever CBI inquiry has taken place, then you should pursue that. Where is the question of this prayer? Quash all illegal appointments. Whose appointments have to be quashed?
Follows the
Can they be
appointments of
quashed without even making them a party? Who are those people?
my laws may be pleased to grant me some time to examine these aspects.
This is a PIL
Yes, my lords.
and these are service matter. How will this PIL is maintained?
Because in fact, it was at the instance of this petitioner only that a FIR was registered against the VC for illegal appointment.
That's all right, pursue that. Right under the CRPC to pursue it.
I give it to my
How
lords.
it becomes a PIL? Why do you want to short circuit the procedure? There's some CBI inquiry and all that.
Because it was only on the footing that this honorable court had also directed an inquiry within a period of 2 months that was not done.
It's all right. What happened to the CBI inquiry?
My lord, CBI case is still pending. And
Inquiry is still not over.
yes, my lord. And the High Court directed inquiry in paragraph number 16 in page number 29, wherein your lordship say that since the matter remained pending before this court for long time, therefore we direct the university to conclude inquiry in the process of appointments.
That is a university inquiry. There's some reference to CBI inquiry now.
My lord, CBI case is registered for the criminal act done.
Even assuming it is there, if there's a direction to complete it, they have not completed it.
Yes,
What is the remedy? Is this a prayer you can make?
I humbly leave it to my lords.
Huh? And why this court must hold an inquiry?
My lords, we were only on the point that since it
That
was
is your
already-
prayer.
Yes,
The court be directed to hold an inquiry. Or we are going to become inquiry officers also.
my lords, it was already directed earlier and not implemented.
Therefore, what is the remedy? Even assuming that is your argument. Even assuming that it's a valid order passed by this court. But direction is not complied, what are you supposed to do?
My lords, filed a contempt.
Can you ask for an inquiry to be held? And how directions can be given and the writ petition is dismissed? Easy fundamental questions. You don't have to get into all these.
My lords, some time may be granted to me to.
No, we are not running a law school. What is praying? It's not, what is this kind of writ petition? Yes, what do you want to do?
My lords may grant me some time, I will read it.
No, we are not granting. You want an order, we'll give it to you.
I'm praying for an order.
Then don't stop us halfway down, because we are going to come down very heavily on this fellow. The petitioner seeks the following release. Primarily the case of the petitioner is that some of the writ petitioners, some of the professors, some of the assistant professors had filed WP 2372 of 2017 seeking for a writ of mandamus to treat the petitioners as having been confirmed on the respective posts of assistant professors and consequential release. The writ petition was dismissed. Thereafter, this present petition is filed, said to be in public interest. By seeking the following prayers. The first prayer is for the High Court to hold an inquiry and quash all illegal appointments. We fail to understand as to how the High Court can become a court of inquiry in order to find out whether appointments are valid or not. It is not the jurisdiction of this court to hold inquiries. Therefore, the first prayer being misconceived is dismissed. The second prayer is to the effect is that the direction and observations made in the aforesaid writ petition be given effect to, and all such illegal appointments be quashed as per law. We have considered the order passed in the aforesaid writ petition. Firstly, is the fact that the writ petition has been dismissed. We are of the view that once a writ petition is dismissed, the question of granting any directions would not arise for consideration. Even otherwise, even if the contention of the petitioner were to be accepted, what the order states in para 16 is to effect that since the inquiry is to direct the university to conclude the inquiry in the process of appointments, preferably within 2 months. The direction, if any, was only to conclude the inquiry. On the contrary, the prayer herein is to give effect to such an order. We do not see any nexus with the prayer and the order passed in the writ petition. The only direction is to conclude an inquiry. Therefore, the question of quashing the illegal appointments would not even arise for consideration. It is submitted that the inquiry is still going on. If that were to be so, the prayer to quash the illegal appointments becomes premature. Until and unless the inquiry is concluded and another material is placed for consideration, there is no material to indicate whether the appointments are legal or illegal. Therefore, we are of the view that the petitioner has misused the provisions of law and has filed this petition. If at all he is a genuine public interest person, he is always at liberty to pursue his remedy in a manner known to law. We do not think that he could short circuit the procedures in law by filing this petition and claiming it to be in public interest. It's a well settled law that there can be no petition in public interest so far as service matters are concerned. Hence, on all these grounds, we find that the petition is misconceived. He's a businessman. He's a businessman.
Lots of small time
Whatever it
contractor,
is, you're claimed as a big time businessman.
small time contractor in
It's a businessman typed with a capital B. I think it deserves to impose some cost on him.
Carlos, he's already a whistleblower and complainant also in CBI.
Yeah, let him blow one more whistle after this order.
It will demoralize him, Carlos. Let it be a warning.
Question of demoralizing counsel. You are a lawyer. You must advise him what right thing to do. Nobody is shutting doors to you. The 20 million remedies that is provided under law. Just because you are ignorant does not mean you can come and file a writ petition. You must advise him what is to be done. When was this order passed? 2017.
2021, the final order of
21.
remanding it back.
You know what is to be done. You don't do that. You want to just come and hit headlines by filing such petition. Not going to accept.
पोस्ट बेसिक बीएससी लीव स्टडी का मैटर है लास्ट टाइम आपने डायरेक्शन दिए थे
Need some more time to seek instructions in the matter. You'll find reply within 4 weeks, Your Lordship, regarding.
हमारे 15 फरवरी लास्ट डेट है एडमिशन की मेरे इस सेशन के लिए
Look in 2 weeks. 2 weeks.
जी
I'll request them.
Lordship, I'm humbly requesting that the matter may be posted for 2nd February as the senior counsel engaged in the matter is out of station.
If the adjustment note filed by so and so, call after 12 weeks.
Lordship, I will argue the matter. Lordship. I will argue the matter, Lordship.
Yeah, that's after 12 weeks. You filed adjustment note, no? Adjourning all by 12 weeks.
Also with the content, order and just C1 in the content. Honorable Court has directed to respondent to consider appointment engagement to the petition.
Yes, what have they done now?
But they have not considered, despite of the joint director by manager C3 has also written letter to take any
If
action.
there's been any future appointment,
Yes, Lordship.
where is it?
In WP, which is a file in, out of 7 persons have been engaged and except the project petitioner has not discriminated.
So which order is disobeyed?
And here P2 I filed with the petition also. May wish with the petition.
What is that order?
Order Lordship that they have cancelled the engagement and thereafter
You are in contempt, counsel.
this is the contempt.
Correct. So which order is disobeyed?
Lordship C1 is.
What is that order?
Lordship order is if the appointment is made. So appointment have been made. So
Where is it? Please show it to us.
Lordship,
Where is the appointment order? Please show.
Lordship, I have already filed the order, some other similarly situated in the improved order which I challenge in the WP.
That will not help you. You have filed a contempt after the WP.
Yes, Lord.
So what order is passed after interim order is granted?
They have nothing passed order after passing the order. They have not complied.
Have they made any appointment?
Yes, Lord.
Where is that appointment order?
Let's, may I permit it to I will file.
When was it made?
Lordship, they have made the order, some other situated persons along with the petitioner, they have cancelled the appointment. But except the petitioner has not considered. And already post is vacant and there
We
is,
are sorry, we don't understand what you're saying.
Lordship, my
You
humble.
please read the interim order, which was disobeyed.
In case any further engagement or to be made with respect to the subject of cosmetology. So cosmetology trade is only one subject and only petitioner is the working at that time. Now she has been removed from the work and some other and the post is still vacant. And there are
What does this order say?
order say any further engagement is
So
made.
is there any further engagement?
Lordship, yeah, joint director has written letter to consider Lordship. Because there is post is vacant. And some students are also,
Is there any further engagement which they have made?
Lordship, other persons who have cancelled the appointment with the petitioner already been engaged, Lordship. And except the petitioner has not in her trade, not been considered.
Has anybody been appointed in cosmetology?
Cosmetology is only a single post is vacant.
Has anybody been appointed?
No, but
Then how it becomes contempt?
because necessary is there and joint director has written letter to consider. C3.
Petition is filed on the ground that the order dated so and so and disobeyed. In terms whereof it was directed that in case any further engagements are to be made in the subject cosmetology, the respondents to consider the case of the petitioner for appointment or engagement.
And
In spite of repeated.
file any return in the WP is still.
ये आप क्या argument कर? ये WPA की contempt है.
WP is also pending.
In spite of repeated questioning, the learned counsel is unable to place any material to show that further engagements have been made subsequent to the order dated 14/11/2022. His only grievance, as we understand, appears to be that the petitioner is not being appointed. That does not amount to a contempt. Contempt arises only when there is disobedience. The order indicates that in case of any further engagements, admittedly no further engagements have taken place so far as the subject cosmetology is concerned. Therefore, the petition being misconceived is dismissed. Yes.
The petition was dismissed for want of prosecution on 7th of September, my lord. Filed the restoration application. The litigant was not aware because the counsel who was engaged was no more now. His juniors were taking care of the case, my lord. Litigant was not aware that the matter is turning up for hearing.
How many advocates were there?
सर काफी नाम थे सर उसमें 7-8.
आप लोग डालते हैं ना 10, 15, 20, 40, एक में 92 आया था. कितना आया था?
Sir, the fault of the counsel litigant may not suffer, my lord.
No, he has to suffer.
The want
वो
of
पुराना जमाने का हो गया. Now it is like that. If you engage a lawyer who does not know the law, then you have to suffer. तो गलती से if you go to incompetent doctor क्या होता है? बाद में recall भी नहीं डाल सकते.
want of
So you have to pay for it. If there is a single lawyer, then it is fine. ऐसा नहीं है 10-15 है इसमें.
sir juniors थे Mr. DS काफी.
अरे जूनियर है, सीनियर है, इंटरनेशनल
6 to 7 lawyers थे सर.
हाँ, फिर वो कहाँ थे?
सर वो litigant को
तो
तो
क्यों लगाते 6-7 आप लोग?
litigant was not aware.
What?
He turning up for.
He has not engaged 6-7 lawyers.
नहीं सर उसको information नहीं थी litigant.
हाँ, कौन देना था?
जब उसने
वो 7 एडवोकेट देना था ना.
जब उसको पता चला ये serious है.
We try to change the system. You oppose it. नहीं नहीं हम सभी का नाम आना है. ठीक है आ गया. Now you have to pay the price for it. So whatever suggestions we make, you always take it in the wrong spirit.
want of
So this is another example. है ना? हाँ, तो क्यों करना है?
सर want of prosecution का dismissal.
Right. तो 7 लोग क्या कर रहे थे उस दिन?
सर अब
7 लोग बिजी थे क्या?
सर inform नहीं किया कि litigant को सर want of prosecution का dismissal है. Merits पे नहीं.
क्यों सुनना है? आप ही को इंटरेस्ट नहीं है, हम क्यों सुन? आपका केस है ना? And you filed affidavit of the party.
Yes sir उन्हीं का.
Absent कौन थे? वो थे कि आप थे?
नहीं सर जो counsels engaged थे वो absent थे.
तो उनका कहाँ है affidavit? जो absent थे?
पर litigant ने ये बोला कि उसको information नहीं थी क्योंकि वो he was not well.
So you must let the advocate file affidavit.
तो
Is the fault of advocate or fault of client?
सर जो engaged original counsel थे वो तो expire हो गए सर.
वो एक आदमी एक्सपायर हो गया ना, बाकी 6 हैं.
कोई तैयार नहीं है affidavit इसलिए litigant ने
तो वो तैयार नहीं है तो हम तैयार होना है क्या?
वो litigant सर वो
If you are so arrogant of not filing an affidavit,
Sir.
why we should accept it? To tell
सर वो
the
litigant
advocate not willing to file affidavit. ठीक है, आपका मर्जी. The recall application, they are arguing.
सर मेरा निवेदन ये रहा था कि वो काउंसिल से एफिडेविट कैसे मांगेंगे सर वो देने तैयार थे.
Advice मांग रहे हो?
नहीं सर मैं लिटिगेंट की वो बता रहा हूँ सर,
नहीं आपका मत, आप जो करना बोलिए, जो करना है कर दो।
अब डायरेक्ट करना मैं उनके भी एफिडेविट
अरे हम क्यों डायरेक्ट करें, आपका ऑफिस कैसा चला, आप वकील हो ना यार, वॉट एवर यू, but default is not because of absence of client, it's your absence. And we don't even ask all these questions. In all cases, advocates are wakalat, and we straight away, without even asking a single question, we recall. करते हैं कि नहीं? But then,
I'll get the affidavit submitted.
but when you become so very principled, we'll also deal with it like that.
I'll get the affidavit filed.
वो करना है.
My lord, may I ask you? Your Lordship, this was a final hearing matter, and since my lords have not dismissed the matter on default, my lords have disposed of the matter.
Consider. We'll restore it and deal with it. 2 weeks at petition.
कंटेम्प्ट पिटिशन लॉर्ड्स, नेमिल कोर्ट से 14/2022 को आदेश हुआ था लॉर्ड्स कि रेस्पोंडेंट अपनी पत्नी को साथ में रखेगा लॉर्डशिप, लेकिन वो आज तक रखने के लिए तैयार नहीं हो रहा लॉर्डशिप। ने लीगल नोटिस भी भेजी लॉर्डशिप, फोन से भी संपर्क किया लेकिन फोन में भी गाली पक रहा है। और एक पत्नी पहले से रखे हुए है और उससे बच्चा भी हो चुका लॉर्डशिप।
Which order is disobeyed?
एनएचआर C1 लॉर्डशिप, पेज क्रमांक 7 लॉर्डशिप।
और क्या है वो?
इसमें पेज क्रमांक 9 में आया हुआ लॉर्डशिप, डिग्री में लॉर्डशिप, दोनों पक्ष आपसी सहमति से साथ रहने को तैयार। प्रत्यार्थी अभिलेख पटेल अपनी पत्नी को साथ रखने को सहर्ष तैयार। अभिलाषी मनीषा पटेल अपने पति प्रत्यार्थी अभिलेख पटेल के साथ उनके घर अर्थात अपनी ससुराल तहसील पनाका जिला जयपुर में पति के साथ रहेगी एवं मायके आना जाना अपने पति की सहमत से करेगी। दोनों पक्षकार ने आज दिनांक 20/12
What is your grievance?
लॉर्डशिप इस आर्डर के बाद वो हमको नहीं ले जा रहा लॉर्डशिप,
हमको
साथ में रखने को तैयार नहीं है लॉर्डशिप।
कंटेम्प्ट कैसा होता है? डिक्री हो गया ना
जी
तो वो डिक्री के मुताबिक वो नहीं कर रहा
जी
है ना,
जी,
तो क्या करना है आप?
तो पनिश किया जाए लॉर्डशिप।
नहीं यार, एक का पनिश ऐसा नहीं होता, पर डिक्री डिसोबेड क्या करना है?
विद लिबर्टी दे डिग्री की चैलेंज करती है,
No, see, you are given consent to draw the decree.
बट
There
कॉन्सेंट
are so many remedies available to you. Either you must challenge the decree or you must go back to the court and withdraw your consent. इतने रेमेडीज रहते हैं आपके पास, कंटेम्प्ट नहीं बन सकता है।
विद लिबर्टी दे,
हाँ?
दूसरी प्रोसीडिंग करने के लिए लिबर्टी।
लिबर्टी देंगे लेकिन आपको पता है क्या करना है?
देख ले,
देख लेंगे। नहीं ये डिक्री हो गया ना,
जी।
अब रेगुलर कोर्स में सिविल कोर्ट में जब डिक्री होता है किया जाता है।
39 में लगा,
हाँ
39 में चल रहा है,
39
2 में लोग
एग्जीक्यूशन डालना है ना,
जी लॉर्डशिप,
डिक्री एग्जीक्यूट करने के लिए।
जी लॉर्डशिप।
बाद में आपको पता चलता है कि वो एग्जीक्यूट होगा कि नहीं होगा, कंटेम्प्ट तो नहीं बन सकता।
सेक्शन 9
आपका
लगा,
कहना है कि आपने कंसेंट दिया तभी डिक्री बना, तो आप उसको विड्रॉ भी कर सकते हैं।
लॉर्डशिप वैसे कंसेंट पूरी उसने दी है क्योंकि वो पहले से ही डाइवोर्स लेने के पहले ही दूसरी पति रखा है।
डाइवर्स है क्या है वो बात नहीं होता है, थोड़ा क्वेश्चन ऑफ लॉ बनता है ना,
जी।
कंटेम्प्ट तो नहीं होता है। आप
विद लिबर्टी दे,
Dismissal will not the liberty to pursue such remedies as
प्लीज लॉर्डशिप।
Yes.
Which teachers eligibility test was conducted in 2018-19.
Ah.
And I have participated, the petitioner has participated and was qualified as per Annexure P4, page number 67, Lordship. He obtained the mark 113.26, qualified for Sanskrit subject. Therefore, Lordship, the counseling list was issued P5, page number 68. My name is at page number 69, serial number 48.
Serial number?
48
Ah.
at page number 69.
Ah.
After the counseling, Lordship, the select candidate list was issued on 20th December 2022, in which my name was not included. But the similar marks, the candidate who have obtained the similar or less marks than me have been included in the list at page number that starts from page number 75, Lordship. Item serial number 84 onwards.
Have you inquired with them why it has happened?
Lordship, I have written a letter to them. Even in the rejected list also was issued. In that also my name is not included.
So where is the response to your letter?
There is no response yet because, Lordship,
Where is your letter?
letter at page number 88, Lordship, P8. It is dated 3rd of January 2023.
Must wait for a reply.
Lordship, meanwhile, because my only contention, Lordship, my name is neither in the select list nor in the reject list. At least that can be clarified. Where am I?
You have instruction?
Instructions, in fact, Your Lordship, in fact, prima facie, it appears, but I do not have instructions though, that the petitioner belongs to the unreserved category. Now, after serial number 84, there is no person from the unreserved category who has been appointed. All of them belong to some of the other reserved categories. So they would be, according to their, the marks obtained by them, they would be accordingly adjusted.
Let's see.
We'll seek instructions.
CA takes notice for R1, issue notice to R2. Honorable end.
Installed. Related.
One pen.
This PIA has filed my lord for removing an encroachment, my lord, on the government land.
CA takes notice for
For all
1, 4, 3, 4. Corrupt ratings.
Okay.
Also, Annexure, Annexure 24 is under challenge, Lordship, whereby the Nagar Parishad has issued notice to the petitioner, Lordship. They are street vendors, Lordship, for their eviction, Lordship. Lordship, they are in position last 50 years, Lordship. And I am only challenging the order, Lordship, only on the ground is that, Lordship. The procedure which has been followed by the Parishad, Lordship, this is contrary to the act, which is give the protection to
Which
the
notice challenging?
Lordship P
P
24, page number 89.
P24.
No, Lordship,
What is that order?
Lordship, show code notice.
What is that order?
Lordship, page number 89. It's a
Yes, what is that? So cause notice. Did you give reply?
Lordship, I have a reply. Lordship. Reply is on page number, Lordship. Lordship, page number 84.
What happened?
Lordship, actually, my humble submission is that, Lordship, that they all the petitioners are running their shops.
They have given you show cause notice.
Lordship,
You have replied to it.
Lordship.
Then what happened?
Lordship, they are marked the areas,
Have they passed an order for eviction?
Lordship, they have passed, they have marked the place, Lordship.
Have they passed an order for eviction?
Lordship, but they are proceeding the eviction proceeding. Lordship, they have marked, yesterday they have marked the area, Lordship.
Is
This-
anything else?
Lordship, my humble submission is that, Lordship, this order, this so-called notice, Lordship, is contrary to the act, Lordship, which is Street Vendors Protection of Livelihood, Lordship.
All right.
This act is provided that, Lordship, there should be a survey, Lordship, with regarding to evict them, Lordship.
Yes.
Lordship, I have mentioned it in the my petition, Lordship, page number 15, Lordship.
Yes.
This section 3 is, Lordship, says that I am coming under the street vendors, Lordship, and section 20 to provide the committee, Lordship, that committee will decide that it will conduct the survey, Lordship. After the survey, Lordship, there is a provision that they will available any other place to me, Lordship. Lordship, actually in this area, I have granted the patta also, Lordship, in the year 1995. That has been granted by the Gram Panchayat, Lordship. So my humble submission is that, Lordship, there should be some protection may be granted,
Yes. Anything else?
Lordship. And my last submission is that, Lordship, that I have relying one judgment, Lordship, which is I have quoted in my petition, page number 17, Lordship. Maharashtra Ekta Hawkers Union versus Municipal Corporation, Lordship, whereby, Lordship, Supreme Court has also decided that, Lordship, some protection will be provided to these street vendors, Lordship, and through Lordship, following this basic procedure, Lordship, which has been clearly provided in that judgment, Lordship. My humble only Lordship. And Lordship, my humble request is on Lordship, they are very poor people, Lordship, and earning their livelihood since last 50 years, Lordship, for the time of their forefathers, Lordship. So my humble submission is that, Lordship, notices may be issued to the state, Lordship. State will file their reply, Lordship, that survey is required or not, Lordship. My only contention is that, Lord, this survey should be required, Lordship. Whether there is a requirement to evict them from that place or not, Lordship. Only.
When we try to talk to you, you don't allow us to talk to you. So our doubt will remain a doubt. If a judge has a doubt, you will never ever get an order. Seem to get pleasure in arguing.
I apologize for that.
Again you interfere.
I apologize for that.
That's not good advocacy. When the bench asks you a question, you must learn to listen. If you have an answer, it is fine. If you don't have an answer, it's all right. But you don't even allow us to speak.
I apologize.
So this will be the fate of your cases. Tell me. The case of the petitioner is that they are agriculturists as well as they have their shops over the certain lands in question. That they have been there for a long period of time. The respondent number, who issued this notice,
Lordship, respondent number.
This is by respondent number 4, Tehsildar.
has issued a notice in terms of annexure P24 dated 22/9/2022.
There are 4 notices for 4 petitioners, my lord. P18, P20, P22 and 24, my lord. With regards to all 4 petitioners, there are 4 available.
Notice was issued under section
Section.
No, that has not been mentioned.
Section is not mentioned.
that they have illegally put up the construction and therefore have violated the provisions of section 187 and 223. So-called notice was given asking him to reply within a period of 15 days, failing which appropriate action will be taken to remove them from shops in question. It is the case that the petitioners replied to the same in terms of annexure.
मतलब P20 one of the petitioner had only
का केस है ना, उनको बोलने दो, आपको नोटिस दिया है क्या? Where is your reply?
Also, my reply is there. I'll
Document. The reply was furnished by petitioner number,
all the petitions,
white annexure. P21 with respect to petitioner number 3. Where is 124 reply?
also only he has only given me.
Others are not given.
No,
We do not find from the petition that the reply of other persons have been furnished. The reply indicates that
sir. Tamra.
thereafter the instant petition is filed seeking to quash the impugned notices and for the constitution of a town vending committee. The counsel of the petitioner contends that the petitioners have been running their shops for a long period of time and they are being illegally disposed. However, in hearing learned counsel, we do not find any merit in this petition. Show cause notices were issued to the petitioner to show cause with regard to their right to stay in the property in question. The only reply furnished is that they have been that they have their shops for the last many number of years. They have not produced any material to indicate their right to sit over the public property. Even notwithstanding the same, it is ultimate. They have also stated in the reply that on many occasions, in view of the fact that they were in illegal occupation, fine has been imposed on them by the authorities. Is that correct? However, it's for the, having considered the contentions as well as the material record, we have the view that all this is a matter to be considered by the authority. It is needless to state that any eviction of a person, even if he is an unauthorized occupation, would have to be done in a manner known to law. The respondents, by following the due procedure of law, had issued them a notice asking for explanation. The explanations have been furnished. Whether it's right, just or appropriate is for the authorities to decide. The material record would also indicate that no further action has been taken by the respondents, nor any order of eviction has been passed subsequent to the reply furnished by the petitioner number 3. Therefore, needless to state that the respondent should act in a manner known to law while evicting the petitioners. Hence, we find no good ground to interpret. Yes.
Also, petitioner working as a PT teacher to work in laws. But
What is your representation for?
representation for regarding of payment laws.
Huh?
Regarding of payment laws.
Regarding
Payment laws.
payment?
जी,
What
sir.
payment?
सितंबर माह से अभी तक पेमेंट नहीं हुए हैं तो उसी के लिए हमने रिप्रेजेंटेशन दिया था जिला शिक्षा अधिकारी
You have given it hardly 1 month back.
लॉर्डशिप
You must give them some time, at least 6 months time for them to reply.
सर सितंबर से हमने अगस्त में ज्वाइन किया अगस्त से अभी तक पेमेंट नहीं हुई
This is for your salary?
लॉर्डशिप
Yes, see, we are not paying salary.
Followed, I will seek instructions or it may be disposed of that.
No direction, ensure that salary is paid.
My lord.
A takes notice for respondents. Call next week.
Covered matter, my lord. Matter involved in this petition is covered by the order dated 26/4/22, passed in writ petition number 6159.
Ordered.
Lord, my services have been terminated by an stigmatic order, Lord, without giving so cause notice to me. The fact of the case are, Lord,
Where were you working?
I was working under respondent number 3 college, Lord, as guest faculty, Lord. The facts of the case are, Lord, that advertisement was issued in year 2018, Lord. I submitted my candidature. After due selection process, I was appointed in 2018, Lord. And since then, Lord, I was working, Lord, till passing of impugned order, Lord. What has happened in this case, Lord? That as soon as I filed, Lord, this writ petition against the same post, Lord, the advertisement has been issued on 20th January 2023, Lord. That I have, Lord, prepared this application for, Lord, the amendment. Lord, no inquiry is conducted, Lord. No notice to me is given, Lord. And P1 says, Lord, that श्री संध्या मंडाले जन भागीदारी समिति विधि शिक्षक के विरुद्ध लगातार प्राप्त शिकायतों अनियमितताओं के कारण विद्यार्थियों द्वारा इनके विरुद्ध किए गए उग्र आंदोलन एवं अनियमितताओं को देखते हुए प्राचार्य कक्ष में आयोजित जन भागीदारी समिति की तत्कालिक बैठक में समिति द्वारा लिए गए निर्णय के परिप्रेक्ष्य में इनका जन भागीदारी
Can you not approach the collector against this order?
Lord, in fact, what has happened in this case, Lord? It seems that there is some decision by the Samiti in which the decision is taken behind me, my Lord, without any so called notice. That, pardon, Lord.
This order, can you not challenge it before the collector?
Lord, alternative remedy is not available in this case, Lord, because the natural justice is violated by the respondents, Lord. The situation would have been different if the, Lord, proper inquiry is conducted with respect to, Lord, this allegation made against me, Lord. Lord, in this respect, I will, Lord, cite the judgment of the Honorable Court also, Lord. So my respectful submission is, Lord, that
GA takes notice for this.
Lord, this application may be taken, Lord, because, Lord, on 20th January, Lord, they issued the advertisement against the same post in which I was working, Lord. Lord, this is with ulterior purpose to make infructuous this case, Lord, in case the appointment are made, Lord, because there is single post, Lord.
That we'll consider it.
Lord, this application may be taken, Lord.
We'll file it then. GA takes notice for respondents. All
1,
of
2, and 3, Lord.
1,
Four
2,
is
and
Pakistan.
3. Give notice to R4, post after service of.
Lord, I pray for next week, Lord, because
Counsel,
I am
the
out of,
students have gone on strike against you. You have been terminated on that
they
ground.
have gone on strike, Lord, because they
Letter.
obtained, Lord, less marks against,
We'll hear you and let them.
after 2 weeks it may be taken, Lord.
So Yes.
Challenging this petition is to the office notification issued by the central government law saying imposing GST at the rate of 15% on the royalty levy.
The GST matter.
Page 110, but page
It's a case of CGST, so notice will be issued an interim order in terms of next year P13,
P13, page 110, Lordship.
page 110.
So and so appears for R1.
Yes, sir.
GA for R2,
R2 and 3, 2 and 4.
2 and 4. You should notice the remaining response. I should do the same one.
I'm off. Always seek permission to file reply in behalf of respondent number 7.
Clearly. Have you given a copy to the other side?
Lordship, I already did. State to file. State has
We
filed.
are also planning to forward the plan over this because the land in respect of the enforcement is actually with the falls within the jurisdiction
Have you
of.
given a copy?
Yes, I've already.
I have not received it. State reply.
State. We still need-
Where is it? The state and respondent number 7 have filed their respective replies. The court, the same is taken on record. Take it next week or 2 weeks?
Whenever your lordship directs me, lord. My lord, permission may be granted to me to my lord, file the documents, my lord. I am the respondent number 8, my lord. I am the, there is allegation against me, my lord, that I have encroached
Response
upon
at
the,
liberty to file additional affidavit. if
my lord. Hold on.
Yes, sir.
There was a delinking order on the last date in 20 and 21. Probably the one other matter, not 10766 of 2020 got left out, not.
Ah,
So these were the three identical matters, not these two, which raised the similar issue, plus 10766 of 2020. That has got left out.
what are these matters?
Now these are related to conservation of the catchment area of the Khandari.
Post along with?
WP 10766 of 2020.
Yes.
Yes, at number 28.
Connect kar do. Alag-alag matter ho.
So these three will be together. 2021 and 10766 would
They're
take
all to be heard together.
all together.
The reply has a weighted manner.
For respondent number 6, praying for a 2-week time to file.
What is this case? What is this case?
Well, it is matter regarding the land acquisition. Additional land has been acquired, madam.
That's why you are not filed reply. Respondent, nobody has filed reply.
Not with lost. 2-week time with lost opportunity.
2 weeks finally to enable respondents to file the reply file.
Proceedings are complete. The respondent 1 to 8 and 9 have filed their.
What is this matter? What is it?
We file an application for vacating of the stay.
It is a property, I submit it is a property which is being used as a Kabristan since more than 100 years. And the documents which were of 1935-36 has not been answered by any of the respondents. My documents may kindly be seen, sir. The Khasra number 1899, area 9.75 acres at Kasba Jatara district, Tikamgarh, is registered in the.
Who has filed vacating?
My lord, I have filed that.
Who are you?
I am the private person who is the owner of the land.
What do you want?
My lord, now there is a stay in favor of the applicant.
What is this modified construction?
My lord, we are constructing my house, we have been demolition by due to your lordship rain. So my submission is that, my lord, this public interest litigation is not maintainable because it is a private interest litigation because he has been, your lordship,
You
approached to.
permit him to do some
No, no,
repair.
no. That document may kindly be seen. There are authorities have answered on my page number 30 may kindly be seen, sir.
Page?
Page number 30 of my petition. Sir.
Ah.
It is an order, it is a letter by Tahsildar Jatara addressed to the present petitioner regarding the mutation of the land in the name of this person. Sir. उपरोक्त विषयांतर का संबंध में लेख है आपके द्वारा वर्ष 2008 से 2009 से वर्ष 2017-18 तक तरमीम प्रकरणों के वर्षवार सूची की नकल 62 आवेदन पद एसडीओ महोदय जतारा के माध्यम से कार्यालय को प्राप्त हुआ है। आपके द्वारा जिस तरमीम के संबंध में जानकारी जारी जा रही है उसके संबंध में आपको 2008-9 के से वर्ष 17-18 तक की दायर पंजी का अवलोकन कराया गया जिसमें भूमि खतरा नंबर 1899/1 स्थित ग्राम जतारा की भूमि के संबंध में कोई भी प्रकरण दर्ज नहीं है। हल्का पटवारी के संबंध में प्रतिवेदन लिया गया। हल्का पटवारी द्वारा प्रतिवेदित किया गया कि वर्तमान चालू नक्शे से भूमि खतरा नंबर 1899/1 की तरमीम तारीख है। There is no record of the mutation of the land in the name of the private respondent. The revenue authorities had admitted this fact. They have found on the physical observation and inspection that the graves are there, sir. And it is an open land, sir.
Yes. My lord, my submission is that
To be heard on.
my lord, that will be heard, that will take some time to argue the matter. But in the meantime, having been permitted, my lord, it will not prejudice to the your lordship petitioner. My lord, I have purchased the land in the year 1991 by virtue and your lordship public.
But you have not stated what kind of construction, what you
Hello.
are doing there. You have to clarify that. You file a detailed affidavit.
I will file it, but my lord, my submission is that due to such condition, my lord, my family is there.
That is all you are telling orally, it is not there in your IA.
Therefore, I filed this application for vacating of stay.
There is nothing-
My lord, I understand, my lord. I will file a detail.
File a better. IA is dismissed as withdrawn with liberty to file a fresh application. So only then if you say, then we can ask him whether it disturbs it or not. So orally it becomes.
The state government also says that your lordship, it is a land which has been purchased by me in
That's
the
a
auction.
different question. If a limited prayer is some
My lord, I understand.
repair or correction. You put
Could it be
we'll
in the
ask
next,
him.
could it be in the next week, my lord? I will file in the meeting. Could it be the next week, my lord?
You file it, then it will come. Yes.
My lord, if, my lord, could it be next week? I will just file.
अरे आप file करो तो.
So grateful, my lord, so grateful. Thank you.
Madam, may I begin?
Yes.
Madam, there are three IAs before my lord.
Yes.
IA 13244, 30244. That is for early hearing.
Which case you are arguing?
24.2.
24?
0.2.
2.
41.
0.2. Point 2. Ah,
My lords, today three IAs are before us.
yes,
First IA is 30244.
yes.
This is an IA for early hearing. Pursuant to our request to the we went to Supreme Court said you make an application. So
13.
this now stands disposed of today, my lord, because the matter is before us.
13 to 44.
So this before the case is before my lord, so
All.
to that extent,
In view of subsequent event,
nothing further to say.
13224 stands dismissed. Yes.
Now, second is IA 6292. This is RIA, which is to be considered,
Yes.
And let me give the details of the third IA. This is the state side. The state IA is 3639 of 23.
Now, what is RIA and what is state's IA? Well, RIA is for grant of interim directions for removal of royalty paid mineral. Royalty paid mineral, apart from the documents that I showed to my lords, in my case, before the termination, my lord had passed this order. This case itself, this is order dated 15/11/21. Sorry, in W3 232557, in this bunch of cases. Where my lords had held that at this stage, it is suffice to hold that in every case, royalty has been paid, the respondent shall not be permitted to charge the royalty for the second occasion. If the royalty has not been paid, then respondents are entitled to proceed under the relevant provision. Consequently, respondents are directed to issue ETP for the material for which royalty has already been paid. Now, this is an order dated 15/11/21 in WP 232/57. My bunch. Only difference is this order was passed before termination. The application that I have moved today is after termination. But the essential time going on being the same, it's a royalty paid material which is lying to be taken away, and under the rules also, transportation rules, anything that even post termination or post expiry of contract, if royalty paid material is lying on the spot, I'm entitled to take it within a month. So this is the background, and now why I'm saying this, my IA should be allowed, is this, Lord. My Lord would see the interim order, first interim order of this court. That is 4th January 22. The last 4 lines are important for us. For all these reasons, the state is directed not to initiate any proceedings against the petitioner in relation to the contract in question. This is after termination. And then the last 2 lines, Learned AG submit that there shall be no retender of the mining area that were granted to the writ petitioner till the next date. Now, my lord would come to the next order, that is 23/5/22. May I read that?
One second.
My lord, sorry.
You are arguing 6292 now. There's already an order passed on that earlier.
That was before termination. They never allowed us.
When was it terminated?
Without
31st of December 2021 is the date.
And this IA is after termination. Those 2 are, my lord, I showed the 2 order sheet.
Even this interim order dated 4/1 is after termination.
Yes, yes.
Ji.
Yes.
And thereafter, when you filed 6292, you have passed an order on 22/6/22 on that, saying that it will be considered at the stage of final hearing.
And against that, my lord, they preferred SLP before the Supreme Court. That order is there on record.
What my lord said is to be considered thereon.
What's for hearing in the usual courts? There on. But I think we have heard you on this earlier.
No, not really in that sense. Because if my lord hears me for 5 minutes, I won't take too much time. I'm aware.
Yes.
My lord, 2 reasons are important. If their IA which is for allowing them to hold auction. I still have 6 months left. Is allowed, one second. Then what happens to my 13 lakh ton royalty paid and 4 lakh cubic, sorry, 13 lakh cubic meter and 4 lakh cubic meter, which is royalty paid, which is lying on the field?
We'll hear them on that, what they have to. Which is your IA?
Yes, sir. We have filed
13.
this interim application. This is IA number 13639.
And their reply, just one second
Yes,
before you
yes,
start.
yes.
I'll not touch any
Yes,
paper.
yes, yes.
Their reply to my IA is, you people have made you have not understood the law properly, they're telling us. There is no question of loyalty. So since there is no question of royalty, where is the question of royalty paid material being allowed to be lifted? I have to only give pages to my lords from the tender, from the acceptance letter, from their reply, to show that they themselves are saying that this is royalty paid. May I show those 3 pages? That's all, my lord. From their own reply. I mean, I'm not going beyond the reply. That is in the context of my eye. They say that there is no royalty. I'm saying your own document show that that you have calculated. This is an amalgamated sum in which royalty is infused. This is your own case. Will not we see page 8 of their reply for a second. My lord, I just 3 pages I am going to read to my lord.
Yes.
But just a few pages to show to my lord that what they are saying is wrong.
Yes.
They don't please page 8 of the reply, just one by one.
Yes.
I'll give few pages and then we can start.
Yes.
The said sand rules,
What you're reading?
their reply of the
Reply to 6292.
in 28431.
The reply to 6292.
Yes. No, this is
My learned friend is referring the reply on merits of the case.
merits. What they have said on merits, because their contention is that there is no royalty. When there is no royalty, where's the question? All those orders don't apply, that rule doesn't apply, ETP doesn't apply.
Yes.
I'm saying you yourself are saying there is royalty.
Yes.
See page 8. Just see, come see please. Page 8.
Yes.
I'll read that. The sand rules. See.
Yes.
Mary.
Yes, please.
PCC. The sand rules 2019, including the improved rules, do not deal with or levy royalty or dead rent on the mineral sand, and the sand rules 2019 are only limited to tender process, annual contract, amount of contract rate, and the various obligations of the party for the performance of the contract. This is their stand. Again at page 11, clause N. Lord, just last for 3 lines. Again, they reiterate the same thing in clause N at the bottom of it. It is submitted that prior to the amendment, the situation was that no royalty was being imposed on the sand rules 2019, but only applicable due to typographical error in the original rule 27, however, same has now been rectified. Now, please come to page 43 of their reply.
Yeah.
This is not the letter of acceptance that we received. Please see page 43, top. प्राप्त दर के अनुसार प्रति घन मीटर देय राशि रॉयल्टी सहित. This is with royalty. And what is the royalty? P27.50. And if we calculate from 80 lakh liters, the amount is the same as what is optioned. Now please come to writ petition, page 135. That is our agreement with them.
Yes.
WP. Page 135.
Yes.
Page 135 and except P5. This is our agreement with the state.
Yes. Yes.
This is para 2 at the bottom. It says, अब ये अनुबंध साक्षी है कि ठेका राशि रॉयल्टी किराया तथा अन्य भुगतान. So they themselves are saying in the agreement that royalty is a component of the amount which is optional. Okay. Now please see clause 28 at page 141. BC paid type of. All part of the agreement. ठेकेदार खदान से खनिज या उसके उत्पादन ले जाने वाले प्रत्येक वाहन को राज्य सरकार द्वारा वैध अधिवहन पास के साथ प्रत्येक गंतव्य के लिए जाने देगा. That's my order, my lord's order of November. You issued ETP for royalty pay, which they got implemented. Now this is their ETP, but this is the statutory form.
Yes.
Where they say royalty has to be paid.
Yes.
And only royalty paid material can be. Yeah, please. May I get this? This is
Yes.
statutory form.
Yes. No, we are aware of that. No, there is no dispute on that.
So they are saying that there is no royalty. I mean, what my lord passed an order in November, they say that.
Yes.
See the form, the next page points to be noted.
Yes.
Required mineral quantity is booked in advance by paying royalty and other charges.
Yes.
This is the ETP.
Yes.
And the last point, amount paid for booked mineral QTP includes royalty, DMF, and MET and income tax as applicable.
Yes.
So after all this, if they say that Lord that no this is not the royalty paid material. So there is no question of you owning the material in that. So it's a contractual amount. It's not merely a contractual amount. It's a royalty paid material for which I have made the full payments, which is lying either in stock or on the lease area. And I am saying that for what I have already made full payment. That is my material. That if you want to have an auction, otherwise this entire material will be part of the auction. Or will go to the auction and benefit for no reason.
Yes.
Even if you have to auction, you first have to allow me to take my wherewithal without. And this is the rule also, Lord. This is the transportation rule. Not page 86 of the rate petition, the annex with the respect. 1811. Page 86. My lords have been able to find that page 11, page 86 of the rate petition. Rule 11, W. In case of expiry or cancellation of the contract, the licensee shall remove the said land available on the storage place within a period of 1 month from the date of such expiry or cancellation of the contract. Otherwise, the mineral available on storage place shall be forfeited. Such forfeited mineral shall be disposed of by the collector as per procedure. Here, both in the case of expiry or termination, that is cancellation. So, rule says I am allowed to take, my lord's order of November says allow them to take royalty paid material. So, all I am asking is, please permit me what is royalty paid, that means full payments have been made to you. That is my material, allow me to take that material. And my lord, in there, if they want to auction it, they should only auction it. I have taken my stuff away.
Yes.
And this is not in the nature of final relief, but I'm not asking for final relief because they are seeking that they want to auction it. How will they auction it with, and will they auction it with my material?
Yes.
That's my case, in short.
Yes, comment?
My lord,
You're arguing 13639.
yes, my lord, RIS 163,639, 13639.
Yes.
2000. Now, my lord, before referring to my IA, my lord, your lordship may kindly permit me to address on the IA argued by my learned friend, my lord. We have submitted our reply to that IA, and that reply is relevant.
Yes.
Well, this IA number 6292 is filed by them, and they have claimed interim direction, my lord, that they be allowed to lift the royalty paid sand, which comes to 13,24,928 cubic meter. So this is one of their claim, my lord. Your lordship was kind enough to refer the order sheet dated, my lord, 22nd of June 2022. Your lordship may kindly refer that order sheet again, may kindly refer it, my lord. Very small order. Post for hearing in the usual course, IA number 6292 of 2022 to be considered thereon. Now, my lord, they assailed this order by filing SLP before Supreme Court, and that order passed by the Supreme Court is annexure R1 at page 9 of my reply.
Yes.
Now, the Honorable Supreme Court has said, madam, that learned counsel appearing on behalf of the petitioner does not press the special leave petition in order to enable the petitioner to move the High Court for early hearing. The special leave petition is dismissed as withdrawn. So, madam, the order passed by your lordship has become final.
Yes.
Madam, they have already withdrawn that SLP and claimed liberty, madam, that they'll move before the Honorable High Court by way of an application for early hearing for final hearing of the matter. And today, my lord, they are again pressing the same IA. So, my lord, my respectful submission is that the IA filed by them is liable to be dismissed on this ground alone.
Yes.
Secondly, my lord, my respectful submission is, now, my lord, there are two matters which I would like to point out. The writ petition listed at item number 24. Now, that writ petition in which virus of certain provisions they are challenged. Now, my lord, I stand corrected, my lord. They have challenged the recovery of rupees 169 crores in WP number 17667 2022. Now, my lord, that matter relates with illegal mining. Now, my lord, second writ petition is 24.2, motion hearing number 24.2. Now, my lord, in that matter, validity of certain provisions of mining rules they are challenged, my lord. And in that matter, my lord, the termination of contract is also challenged. My lord. Their contract was terminated on 31st of October 2021.
Yes.
Now, my lord, we have also, in lieu of termination of contract, we issued recovery of rupees 63.49 crores. Now, my lord, there are two important things, my lord. In item number 24, there is a huge recovery of rupees 169 crores. In item number 24.2, after termination of their contract, we have issued order of recovery of rupees 63.49 crores. Now, as on date, my lord, they have not paid single penny. Now, my lord, at the stage of passing of interim order that no course of action shall be taken against them. My lord, we have not prayed before the Honorable Court that at least they may be directed to pay the 50% of the amount sought to be recovered from them. So there is no such direction. A huge amount is lying outstanding against them, my lord. Now, my lord, they have filed this IA and claiming direction that they be allowed to lift the sand, my lord, on the pretext that it is royalty paid sand. Now, my learned friend, by referring to certain paragraphs of my return, has tried to take the Honorable Court on the merits of the case. Now, my lord is not hearing this writ petition on the merits. Rule Nisi has already been issued. Now, it is to be heard, my lord, in due course, as per the order passed by your lordship on 22nd of June 2022. Now, if they want to press for final hearing of this writ petition, they can file early hearing application and make a prayer before your lordship.
Yes.
I am sorry, I should not advise them, but your lordship may kindly appreciate this fact, man. They, my lord, in various writ petitions, my lord, whenever my lord petitioners filed the application seeking a direction that they be allowed to lift this quantity of sand, my lord was kind enough to direct that you go before the collector for verification of the stock. Here, my lord, we have already verified their stock. Your lordship may kindly come to page 14 of the reply. Our reply, my lord, to IA number 6292. Now, this is the verification which we have already done. And your lordship may kindly see, my lord, if we allow them to lift the sand, no, no, we will not have any source to recover huge amount of rupees 169 crores and 63.45 crores, my lord, from the petitioner. They have not deposited single penny, my lord, with us. Now, my lord, we have, with this backdrop, my lord, I'll take your lordship to the IA which we have filed.
Yes.
This is IA 13639 of 2022. Now, my lord, now your lordship may kindly appreciate, my lord, this important fact. Now, my lord, there is a scarcity of sand, my lord, in district Hoshangabad. We are not in a position to initiate NIT proceedings, my lord, with respect to district Hoshangabad in the light of interim direction passed by the Honorable Court. The Honorable Court has not only stated the huge amount of recovery, but also restrained us, my lord, from initiating NIT process. Now, my lord, due to that, what is happening? Now, my lord, the general public, they are not receiving sand. Now, my lord, we are not in a position to curb the illegal mining activities in district Hoshangabad. Now, my lord, lot of development work, my lord, relating to infrastructure, my lord, of the state government, that is adversely affected due to this, my lord. Therefore, my lord, we have moved this IA that, my lord, we will not initiate any recovery proceedings against them. The amount of rupees 169 crores and 63.45 crores may be kept subject to final outcome of this writ petition, man. We will not recover a single penny from them during pendency of this writ petition. Now, my lord, the contract has already been terminated in December 2021. But they have no right to seek any direction against the state government, not to initiate NIT proceeding. Now, your lordship in various writ petition involving similar issue was kind enough to pass interim orders, my lord. Those orders are there, my lord, on record. I would like to refer those orders. My lord may kindly permit me to refer those orders, my lord. They are part of this reply, this IA. Now, my lord, the first order is dated 13th of May 2022, in which my lord was kind enough to direct that, however, the said interim order will not prevent the respondent state from proceeding to call for a fresh NIT. Then, my lord may kindly refer the order sheet order dated 27/1/2022. In this order also, my lord, in the second paragraph, in the facts herein, the bank guarantee has also been encashed that the contract has been terminated, and furthermore, so and so submits that a fresh NIT has already been published. If that were to be so, there cannot be any interim order against the state to go ahead with the NIT. However, in the interregnum, the respondent state are directed not to initiate any further proceedings against the petitioner for recovery of any money. The bank guarantee that has already been encashed shall remain. Then, my lord, order dated 11/5/2022. Again, however, the said interim order will not prevent the respondent state from proceeding to call for a fresh NIT. Then again, my lord, order dated 28/6/2022. The same direction is there. And the last order is dated 28th of January 2022. So, my lord, by all these orders, my lord was kind enough to grant liberty to the state to initiate NIT proceedings so that, my lord, there may not be scarcity of sign. The general public shall not may not suffer because of this, my lord, and the infrastructure development work of the state government may not adversely hamper. So, keeping that aspect in view, my lord was kind enough to grant that liberty by specifically observing that the amount shall not be recovered from them. So, we are not going to recover any amount from the petitioners, my lord. Secondly, my lord, they are talking about their stock. They are saying that it's a royalty paid stock. Yes, my lord. That stock is in their own custody, my lord. At best, my lord, what we'll do, we'll not put that stock in auction, my lord, in the NIT proceedings, with respect to which we are seeking liberty. So, my lord, my respectful submission is that the interim order may kindly be modified to this extent that that state government may initiate fresh NIT proceedings, my lord. We will not put the stock which is there in their possession, my lord, as part of that NIT. That much we will do, and my lord, we will not initiate any recovery proceedings. This is my most respectful submission.
What is the royalty paid stock according to them?
My lord, we have disputed it in the return. We have said no, it is only
What is the
annual.
stock according to their claim, how much is it?
Yes, what is lying there may not be actual.
13 lakhs?
30,24,928 for which royalty is already paid, but we have paid. On
So
the,
that is their claim.
and it is paid and it is on the port payment. And then for 4 lakh.
सर पेज 16 देख लेंगे जो हमारा स्पॉट इंस्पेक्शन रिप्लाई था वो पूरा क्लियर हो जाएगा ये स्पॉट वेरिफिकेशन किया है इसमें पैराग्राफ
But
8
this
देख लेंगे
13 lakhs, whatever, is it reflected in your own portal?
सर कहीं पर इसमें आ रहा है योर लॉर्डशिप में काइंडली सी पेज 16 पैराग्राफ 8 of the reply, my lord. Reply to their IA number 6292. This is relevant, my lord. Now, this is the inspection report.
What they are mentioning is stock areas. We have two areas where our sand is located. One is the mining area, one is the stock. Stock area is 4 lakh odd, mining area is 30 lakh odd, for which royalty is paid.
My lord, there is a variance in the quantity which is placed in the portal and the quantity which is found at the time of the spot inspection. And keeping this aspect in view, my lord,
According to you, how much cubic meter of royalty paid?
paragraph 8, my lord, page 16. This is the actual position of the stock. प्रकरण में अनावेदक के स्वीकृत 8 भंडारण जी
The stock area, they are saying 5,740. We are saying it's 4. they are saying
R1.
it's 2.
ये
R1.
जी जी ये है पेज 14 देख लेंगे साहब ये स्पॉट इंस्पेक्शन रिपोर्ट है ये दिस इज एनेक्शन R4 है R4 माय लॉर्ड में काइंडली कम टू पेज 16 of annexure R4, paragraph 8.
The reply dated 11th October.
And it was filed on 15th January this year.
May I confirm the extra document?
Page?
Once.
Page 16, madam.
Yes. Yes, what do you say?
Now at paragraph 8. प्रकरण में अनावेदक को स्वीकृत 8 भंडारण अनुज्ञप्तियों का खनिज अधिकारी नर्मदापुरम के प्रतिवेदन दिनांक 27/4/22 द्वारा प्रतिवेदित किया गया है कि भौतिक सत्यापन में दिनांक 12/1/22 व 13/1/22 के माप अनुसार उपलब्ध मात्रा के पास अंतर की मात्रा क्रमशः 1,38,532 घन मीटर कम है, का स्टॉक कम पाया 1,01,38 क्यूबिक मीटर, देन 80.515 घन मीटर कम और 448.81 घन मीटर अधिक, यहां पर अधिक पाया। टोटल बता रहा है 80 घन मीटर और उसमें मात्रा ज्यादा निकली है 448.81 घन मीटर, फिर 4,126 घन मीटर कम आया है और इसके बाद 297.74 घन मीटर अधिक और फिर 1,821 घन मीटर अधिक। इस प्रकार कुल 2,25,743 घन मीटर पाई गई है।
According to you, it is only 2,25,000.
जी,
Royalty paid.
जी, no, we are disputing it. This is the total stock which is found at the spot.
How much?
2.25743.18 cubic meter. And this is the sum of the figures which are mentioned above, my lord, in the same paragraph. इसमें 1,38,532 घन मीटर कम, कहीं कम पाई गई, कहीं पर थोड़ा सा ज्यादा पाई गई, ऐसा सबको टोटल करके। और सब पैराग्राफ 9 पे जो है वो रिकवरी इसी आधार पर ये निकली है। योर लॉर्डशिप में काइंडली सी लास्ट 2 लाइंस ऑफ पैराग्राफ 9।
Their claim is some 13 lakhs and odd. Royalty paid. Cubic feet.
My lord, this is
Not their case.
this is their case, my lord.
So according to you, what extent is royalty paid or nothing is royalty paid
My lord, we have said that they have not paid royalty
at all?
at all.
Okay.
This is our stand in the return, and we'll establish it, my lord, when we'll
Because you mentioned if it is royalty paid, we'll exclude that and go for NIT for the other. So you want to know how much according to you is royalty paid?
My lord,
Is that on record?
yes, my lord is right, my lord. Your lordship may kindly see paragraph 8 and 9 of the same inspection report.
Yes.
My lord, we have, in paragraph, we have found 2,25,743 cubic meter of sand in their possession. That much stock is in their possession. Then in paragraph 9, last two, paragraph 9, my lord, last two lines, we have, like, after taking into consideration all these facts, my lord, we have said that this much amount is to be recovered from petition, 1.69 crore. So your lordship, we are seeking only, my lord, we will maintain the status of this much of stock. We will not disturb it. But barring this stock, my lord, we may be granted liberty to initiate an IT process. We will not disturb this much of stock. We are seeking liberty that we will put mining into mines into the NIT process. We will not disturb the storage. And the quantity is already there, Madam. We will not disturb that quantity.
According to them, it is 13 lakh cubic feet.
Your mining area.
Mining.
This is in the storage area. I'll just show you.
No, we will not disturb the storage area.
area.
And my lord has put a specific query from me. How much is the sand which is royalty paid? Now, my lord, we are disputing. My lord, there is no sand available against which they have paid the royalty. We have issued demand notices with respect to royalty also. That is the stand we have taken on the merits of the case.
Then we'll hear you later.
Yes, ma'am.
Now, his claim is that there is already royalty paid sand that has already been extracted.
Which was reflected in the port.
So
Then, my lord,
so
your lordship.
that we thought, you said that except that rest we will put up for auction.
My lord, that your lordship has may kindly permit me to refer one order in which your lordship was kind enough to direct the collector to verify it in their presence. We will verify the stock again in their presence.
So that is all heading towards the final hearing.
Yes.
But as of now, since you are pressing for an interim order, they also want interim protection. We assume that what you said was, if it's except the royalty paid sand, rest of it you will put up for auction. That is your prayer. And he is as of now interested only.
Your lordship, our prayer is this, my lord, that we will put the mining area into auction. We will not disturb the storage area. So we are not going to auction sand. We are going to auction mining area. That is the liberty we are seeking, ma'am.
Short points. One is storage area, one is mining area. Get 13 lakh cubic sand in the mining area for which we have paid royalty, which royalty is reflected in the port. Number one. Number two, I have 4 lakh odd cubic meter of sand in the storage area. And in the storage area is a licensed area. From this area, we take it to that area,
Yes.
which is 4 lakhs. They inspected. Please see that order which my lords have stayed. In fact, this order also stayed by my lords.
Yeah.
I'll just come to that. Please see page 16. Para 7, प्रकरण को विधिवत पंजीबद्ध किया जाकर मैसर्स आरके ट्रांसपोर्ट एवं कंस्ट्रक्शन लिमिटेड सो एंड सो को पोर्टल एवं भंडारण स्थल पे पाई गई भिन्नता के संबंध. So this is a case where the storage area is being inspected, not the mining area. And they're talking of the portal for portal. And they say that you are reflecting 4 lakhs, but on spot we are finding 2 lakhs. So they are now saying that 2 lakhs, which is, I'm saying it is 4 lakhs. They're saying it is 2 lakhs. They said this is illegal. If I am saying my quantity is more, they're saying your quantity is less. They call this illegal. And they said now we are going to recover 169.37.3 very big amount from you with penalty. That is what my note stated. That is order dated 5/8/22 in WP 17667. When my lord saw the absurdity of the order, I mean, I am claiming that I have paid 4 rupees for 4 tons. You say, look, when I went to the storage area, I only found 2 tons. So if 2 tons is less, that doesn't mean that I have not paid royalty for that 2 tons. I'm saying I paid for 4 tons. So they're saying, no, now that you have said, I have, and this inspection is also ex parte. It's not in our presence. They say it is 2 lakh tons. And so now, for this 2 lakh tons, I'm going to penalize you. And that penalty, my daughters. Because portals reflect 20.
Will it make a difference if there is a joint inspection which is conducted?
We'll welcome that, Lord. We'll welcome that. And if we have...
It has to be some clarity, because one thing is so far as the protection of prosecuting you is concerned, that is dependent on the final hearing.
Yes.
The other is the interest of the state, because they cannot just keep things
in limbo. Both.
So either way, we need to work out some solution. If we have a viable solution, it is fine. Otherwise, the other option is either to allow your IA or to allow their IA. Some call has to be taken.
So,
but here when there is such a huge variation,
it
may not be proper for us to take a call on that now and straight away. Because even those other entry models which the state is relying, maybe the facts are same, maybe they are different. But the fact is we have allowed them to go ahead with the NIT subject to...
Because none of them were fighting the matters. They only came for recovery, for against the recovery. We are fighting a matter, we are saying we were not at wrong.
Everyone in this portal is a fighter only. Everybody is fighting.
So just let two things. I
think if you both of you agree, I mean...
Let there be a joint inspection one, and let the figures of the portal come in.
That's on record itself.
Yes,
We'll comply with your lordship's direction.
But no, it's
what
a
has happened,
suggestion. Whether that will help in taking a decision.
We'll hold a joint inspection. In fact, what has happened, Manoj, on the last occasion, we have issued 2 show cause notices to them. We requested them to keep their representative present at the spot. Now they failed to appear, Manoj. In paragraph 7, it is mentioned. So your lordship may kindly direct them to approach Collector Manoj. I am giving an undertaking, Manoj, that we will hold joint inspection.
It's a date now itself.
Ji. No date hold. Any. But Manoj, NIT may be kept apart from this, Manoj. This is, we are not.
Now let's take it to the next step, and then we'll take a call on that. That would be more fair, because we'll have something to decide on. As of now, we have to decide based on evidence.
Well, for
on the factual aspect,
my respectful submission is, whatever may be the stock, if it is which is found, Manoj, after joint inspection, Manoj, I am giving an undertaking that we will not put the stock in auction proceeding. Manoj, my undertaking may be recorded. We will put only mining areas in auction process. So, Manoj, that much is very clear, Manoj. I am making this statement. Manoj, will not put the stock in auction.
No,
your lordship may kindly record my statement.
How much time will it take for this inspection? Roughly? week you can finish it.
After 2 weeks.
Not that you're going to,
अब मैं तो
not going to go there with a weighing scale.
वो साहब 6 महीने बचे हैं और बहुत प्रॉब्लम जा रहा है होशंगाबाद, बहुत सीरियस प्रॉब्लम जा रहा है.
Take it next week
Yes.
and close it.
बिल्कुल. Any fixed date may be.
Are only one suggestion by them. My small suggestion, it's their problem. I have deposited money in terms of cubic meter example. How much I have removed, they know. How much is lying in stock, inspection will say. So whatever the quarter reflects is my stock. That's all I'm asking you. So whether it be lease area or whether it be storage area. Both places reflect my stock. I'm not asking for anything beyond that. Not what I paid, what is in their portal. Now, problem now is they say that there's no royalty. First, that is the problem. They are not accepting it.
That is the issue
They
which
say
is
there's
to
no
be
royalty at all.
decided by in the writ petition.
We'll
The
order,
lordship may kindly.
we'll order
kindly
a joint inspection.
In fact, my lord, we are ready to hold the joint survey. There is no problem. And we will conduct joint survey only with respect to the storage area.
No.
Storage area. That we will do, my lord. But my lord, my respectful submission is, my lord, my undertaking is, my lord, that we will not put the storage area in auction. But they should not have any problem. Now, my lord, so far as quantity of sand is concerned, that we will inform the Honorable Court after conducting joint survey that this much is the stock found in the storage area. But my lord, for conducting that joint survey, my lord, the NIT proceedings may not be stayed, my lord, because it is, my lord, it is not at all hampering the interest of petitioner. His contract has already been terminated. He is not having any interest to seek direction, my lord, to stay the NIT proceedings. Now, my lord, he has got the interim protection, that huge amount of rupees 169 crores, that shall not be recovered from him. In another writ petition, there is again interim order, my lord, that we should not recover 63.45 crores from petitioner. So we are again giving an undertaking that we will not disturb the quantity of sand available in the storage area. But we are seeking direction that we may kindly be permitted to put the mining area into auction, my lord, for district Hoshangabad. My lord, for that, at least, my lord, the petitioner should not have any problem. Because, my lord, his contract has already been terminated. We have protected the interest of petitioner, my lord. We will not conduct any recovery.
We'll take a decision on that also, whether
Ji.
payments have to be made by him also. Shri Vivek Thankar, learned senior counsel, appearing for the petitioner's counsel, as the learned advocate general. Does the counsel submit that it, in order to consider the respective applications, it would only be appropriate that if a joint inspection is ordered with regard to the storage area of the extracted sand. It's only then that it would be assistance to the court in order to decide the consideration of the pending applications. The learned advocate general submits that on the previous occasions, even though notices were issued, the petitioners did not participate in the joint inspection. Be that as it may, it is suffice to direct the petitioners to appear before the collector. Collector,
Collector Narmadapuram.
tomorrow?
Kal.
Tomorrow. You first appear and then let him pick.
Kal.
Tomorrow at 11 a.m. Thereafter, the collector to decide when the joint inspection would take place. Preferably to submit a report by next week.
Tomorrow is Republic Day, so
Okay, day after two.
he may not be available.
All right,
Week
day
end,
after. Day after Friday.
Yes.
Collector to preferably submit a report within
15
Not any fixed date after 10
So
days.
they'll have made-
at
After
the
10
point
days.
of time after completing the joint inspection.
After 10 days, Margaret, any fixed.
We have said immediately, let him decide.
Please. Liberty may be granted to us to mention, Margaret, no sooner the inspection is
Yes.
completed. We'll mention this thing.
The liberty to councils to get this matter listed thereafter.
But one last
I'm
point.
sorry.
We've also paid royalty for the 13 lakh cubic meter.
No, we'll take a call. on
Royalty is
every-
seriously disputed by us, Margaret.
That area is different. That's why I'm saying.
No, correct. Once this comes, we'll take a
Sorry.
call, we'll take a call on all these issues.
Very good.
Including their fear that there's a blanket stay given to you. So all those we will,
Manoj, they can give us our material, we'll go.
they are saying, give us the money, then you can go.
I'm sorry.
We have said we will liberty to move it the moment the report.
Absolutely.
In this matter, the dispute is with respect to re-evaluation of mark sheet, my lords. We have re-verified the answer sheet of the petitioner and he is entitled for 10 more marks, my lords. So by that, he'll also entitled for grace marks. So we'll take all remedial steps, my lords. This may be taken up after 4 weeks. We'll issue a fresh marks.
Learned Council, the respondent submits that the re-evaluation has been done.
After, yes, ma'am.
You have done the re-evaluation.
Re-verification, my lords.
The re-verification has been done and certain marks are required to be granted in favor of the petitioner. Therefore, he seeks time to effect these said changes. The request call out of
4 weeks.
एग्जाम डेट भी है
जरूरत नहीं पड़ेगी पास
कब है एग्जाम?
3 नंबर्स कम थे अगर मिल
मतलब
जाए तो
he would be passing, so he does not require to appear in the compartment.
ट्रेन को पास हो
This case, Manoj, mining deed was granted.
It takes notice for this. Yes. Yes, Mr.
Milord, this is Milord for execution of mining deeds, Milord. I've just been informed, Milord, that the state government is, Milord, executing the deeds today. I'm praying it be taken next week, Milord. If that would be the case, I'll make a statement.
Lease for whom? In
Milord,
your
lease-
favor?
In my favor.
Record his submission.
Milord, I have just received the instructions, Milord, put it to next week.
अरे क्या है वो?
Telephone-
You're a government advocate. क्यों इतना डरते हो? Instructions है कि नहीं?
Return we have filed opposing.
That's all right. We'll say on instructions you're submitting.
215.
Brother, the status of an advocate is quite high.
Lord, I could not
And if
enter
you
the
make a
collector.
submission at the bar, we trust you.
Lord, I have to get.
You are
myself-
telling us don't trust us. नहीं नहीं.
Lord, I have
हम
to get
अंगूठा
myself-
दे के फिर करना है.
215, Lord, I'll make. Blank.
Government advocate, what is this? Yes, sure.
But on the last day, while your lordships were dictating the order, Milord, respondent number 4's particulars were not there, Milord, so matter was adjourned. Milord, this is a case where, Milord, in 2018, a stone query was granted, Milord. Now, by the impugned order, Milord, after 5 years, the grant has been cancelled. My registered lease is still existing. And our full bench says, Milord, suo moto power cannot be exercised beyond a period of 6 months. They have cancelled it suo moto, Milord, after 5 years.
my environmental permission is there, my air water permission is there.
Government,
Lordship had issued notices on the last day, my lord. It was a bad luck, my lord, that respondent had.
it only says call up to vacation.
Yes, what transpired was respondent files, but address was not there. My lordship dictated the order, and to my bad luck, my lord,
What order we dictated?
lordship issued notice, and in the meanwhile, lordship said the area would not be given to third party, my lord. This sand query, my lord.
That day, I think you had
That-
luck. But
I had a good luck. Today I have.
today we don't know whether.
He has remedy, my lord, of appeal. So he took that objection last day. He
It
took
takes
all that.
notice for 1, 2, 3, 4. Issue notice to
5.
R5. Stay of the impugn order. What is this order?
My lord, order is cancelling the initial grant, whereas annexure P3, the registered lease stands, my lord. And that is so moto after 5 years, my lord.
Stay of the impugn order dated so and so so. The respondents are at liberty to file an IA for vacating or modifying.
Well,
According to challenging order dated reference to petition number 30175 thereby. In the lordship, I have been transferred from Sivni to Sagar, lordship in Janpat Panchayat department. And my service is remaining only 9 months, lordship. And I have been transferred on the basis of the bribe case has been registered against me by the Lokayuk lordship. Only 9 months are remaining, lordship. And the learned honorable report lordship have given the order lordship like this.
That's because the PC Act has been invoked against you.
Yes, lordship.
Case is registered.
Yes, lordship.
So it should have been kept under suspension.
Yes, lordship.
ये खाली ट्रांसफर किया है
नहीं सस्पेंशन नहीं हुआ लॉर्डशिप
तो करना पड़ता है ना
that will be there lordship. Lordship, I am praying only for the only I am praying lordship. The only 9 months are remaining in my service. मुझे headquarter पे
इसीलिए पीसी एक्ट का केसेस लास्ट 1 ईयर में ही ज्यादा हो जाता है
lordship.
है ना
So I am praying only that 9 months are remaining. I may be remain there in headquarter lordship.
This is a very mild order they have passed. They should suspend you and initiate charges against you. And if a criminal case is registered, you are deemed to be under suspension, no? ऐसा नहीं है?
After filing of challan.
That's the order passed by the learned judges in dismissing the petition. The petitioner has appealed. The petitioner challenged his order of transfer. Various grounds.